our succession and estate planning session. My name is Chen Ganesarajah, and I'm the managing principal at Wealthbridge. In terms of today, we're going to be talking about a wide variety of items, just basic things like, hey, what's the difference between succession and estate planning? Things like what are some of the strategies and some of the legal components. I do have Kubes Nava from Nava Law here with me as well, and he'll be presenting a little bit on some of the legal tools that are available. We'll get a little bit into estate planning and taxes in general, and then we'll also get into some of the funding mechanisms that the ultra high net worth clients typically use as it pertains to estate planning. First things first, what's the difference between succession and estate planning? I kind of keep it simple in general sense. When I think about succession planning, for me, it's a very straightforward, hey, what's the exit strategy? I want to exit from the business at one point or the other. What's that exit strategy? But what I'd like to keep in mind is the simple fact that for a lot of business owners that I speak to, if I speak to 10 of them, 5 of them will say a good chunk of their investments is really in their business, that their business is worth a good chunk of their wealth. So that becomes also their retirement strategy as well for some of them, right? A lot of them put all of their effort in building the business. So for them, the succession part of it is not only transferring out their business, but also making sure that their retirement is essentially taken care of. And even within the succession part of it, I always say there's the management component and then there's the ownership component. It's very common sometimes for people to sort of give out their ownership part of it to somebody else, but they may still be involved as part of the management of that firm for X period of years or X period of time. And for them, that's important. Estate planning on the other side is, for me, it's basically, hey, if I'm no longer around, how am I going to make sure everything that I've built over these past years essentially gets passed down to the next generation in the most tax efficient manner? Whether you like it or not, the estate planning part of it will be forced at one point or the other. The question is, can we do that in the most tax efficient manner by essentially doing a bit of planning? Succession planning involves just for your business for most part. Estate planning is your business as well as your personal assets altogether. Why does succession or estate planning matter? There's a wide variety of items. I'll quickly touch base on most of them. The first one being, let's start with providing for and protecting your loved ones. I always say, whether we like it or not, my family, my daughter, they're used to a certain lifestyle based on my income. And that income, it might come from my business, it might come from other sources of income. But if I'm no longer here, I still want to be able to make sure that I protect that income at the end of the day. So planning for that ahead of time is crucial, because that's the only way I can make sure my family can still maintain the same standards of living if I'm not here. The second part of it I always questioned is, some of you in the room may have kids under the age of 18. If something happens to my wife and I, who's actually going to be the legal guardians of my children? For me, if I don't get an estate plan done, which has different tools which will help put some of these things in perspective, I'm essentially leaving them out to dry and not essentially putting plans in place to make sure that they are taken care of. Like I said, if I speak to 2 business owners, one of them will say their exit strategy is their business, or their retirement strategy is their business at the end of the day from the exit. So we want to make sure, as we are building that out, we are doing everything we can to extract, obviously funds from the company to yourself in the most tax efficient manner. That's one of the biggest problems that we all talk about. Hey, as business owners, we get a pretty decent small business deduction rate up to $500,000. Our tax rates in the business side of it is pretty decent at a lower rate compared to personal income. But how do we now access that income from the corporation to yourself during your retirement years in the most tax efficient manners? Minimizing your tax liabilities, I've always said this, at the end of the day, I'm a strong believer, I'm not going to say anything today that's going to be like, holy smokes, we're going to come up with some crazy strategy to be able to evade taxes. That's not the idea here. The idea is there are tools that are legally available. If you end up using it, you are able to minimize taxes whether you like it or not, right? Bottom line is, I haven't come across any business owners who say, I worked so hard to build this $10 million business, but I'm more than happy to give $2-3 million to CRA when I pass away or when I exit. Nobody has told me yet. If somebody tells me, I'll be very surprised. But bottom line is, if you put the right plans in place, you are definitely able to minimize taxes. Distribute assets the way you want. Again, another reason from an estate planning perspective, If I want to make sure my family is taken care of, and I also want to make sure some of my assets go to certain kids versus maybe I want some of my assets to be donated to a charity. I mean, one thing I've learned with a lot of business owners is they're ready to give back. They're giving back to the community is a very important aspect of them. If I want to make sure the assets get distributed exactly the way that I want and not by the way the provincial standards are. So if somebody passes away without a will, the province gets to dictate who gets all of your assets. If we don't put a simple tool like a will in place, whether it's personal, even if you're not a business owner, whether it's on a personal side or a business owner, you're leaving an entire mess and you may not know who is actually going to be inheriting a lot of your assets. And we're leaving that up to the province to decide what happens with your assets versus even though you put in all the hard work. So if you don't get an estate plan done, again, when I say estate plan, it takes into consideration many things, and a simple will can solve that problem to determine who actually gets your assets if you're no longer around. Continuity of your business. I've spoken to many successful business owners, guys, and one thing I've realized is when they talk about their business, it's like their baby. It's like, it's almost just, it's their kid, it's their baby. They've put in all of this work, and it makes it actually makes their identity of who they are at the end of the day, their business. And a lot of business owners who have such passion for their business and who treat it like their identity, the one thing that they're keen on is, even whether they're here or not, the vision for that business should continue. No successful business owners will be like, oh yeah, I'm not here, I don't care if my business fails tomorrow. If you want to make sure the continuity of your business is there, you need to make sure you're getting in some type of estate planning done. Protection of your assets. I own a company. It's a very successful company. There's $500,000 of assets in that company today. Somebody comes and sues me tomorrow. Is $500,000 in that corporation now, is that actually subject to creditor exposure? Simple question, simple things. We don't often think about it, but if we hold excess amount of money or assets in a corporation, and if there is creditor exposure or liability exposure within that to that company, very simple. It's very normal for people to get sued in business. That's a reality, and depending on what type of business you're in, it's very normal to happen. If you don't find mechanisms or put protection mechanisms in place to help protect, preserve that your value of that company, you'll end up losing a lot of your assets to creditor exposure and liability exposure. So we should make sure we get an estate plan done. We understand what's happening to make sure that we can actually protect the assets you're building at the end of the day. The last part of it is maintaining family harmony and donating to charities. I'm a strong believer, so I'll take a perfect example. We're dealing with this right now, a client who's built a multi-million-dollar business. They have 2 kids. They want to make sure one kid is actually ready to come in and take over the business, but another kid wants nothing to do with the business. Being fair does not mean being equal at the end of the day, right? So we want to be fair when we're doing certain things. So he might want to make sure he gives a $2-3 million valued business to the son because the daughter wants nothing to do with that business. So he wants to make sure the son gets that business because he's the one who is going to take that business to the next step. But how does he equalizes the estate? What is the other daughter going to get so that she gets something in fair value so that you maintain family harmony? Because if you don't put the plans in place and you leave things up in the air when you pass away, one son will say, I want this. The other person could say, I want this. Whether we like it or not, guys, and Kubes being in the legal side of it will touch base on this a little bit further. But estates get, there's a lot of estate litigation that happens because we don't put the proper plans in place. You want to maintain family harmony even when you're not here. You got to make sure you get the planning part of it done because you've built, and people who have wealth, they have different set of problems. Then let's say if you haven't built that same amount of wealth, you may have different set of problems, but people who have wealth, they have significant amount of problems at hand that if they don't get some of their planning stuff done, it'll end up creating more chaos to the family than actually creating any type of family harmony. I always say this, a lot of successful business owners, they've lived a life of success. And oftentimes they're ready to make sure that life of success turns into a life of significance at one point or the other. If you don't get that planning part of it done, you may not, instead of supporting your favorite charities, you'll end up paying a lot of money to CRA. Does CRA deserve some part of it? Yeah, sure, why not, right? I mean, that's part of the process. I'm also a strong believer you got to pay your fair share of the tax, but I'm not the person who will be like, yeah, you got to pay 40% of your assets has to go to CRA. So if you get some of the basic planning done in place when it comes to estate planning, we can make sure your family wins, we can make sure your favorite charities win, and we can make sure we can disinherit CRA as part of that process. But again, nothing I'm going to say today is going to magically make people a millionaire or do anything crazy like that. It's basic fundamental tools that we don't often spend a lot of time to sort of, learn about just because we're busy. As business owners, you guys are a ton on your plate. Sometimes it's very hard to get a lot of you, a hold of you because you guys are just busy. No questions asked at the end of the day, right? That's your DNA. That's exactly what you're going to be doing. So, but all I say is if you're building all of these assets, make sure you're doing enough to help protect those assets. And whatever you intend to do with those assets is what happens when you're no longer around. Estate planning, it's an ongoing process. And it's a process that continuously changes over a period of time. Whether we like it or not, 1 in 2 people in Canada get a divorce. So I may have listed somebody as a beneficiary today, but maybe that beneficiary changes tomorrow. But I'm also a believer that you can't wait to start that process because you won't have all the answers just yet. Perfect example, let's say I'm a business owner, I have a child who's about 13, 14. Looking at him, I know he's going to get into the business, but I can't put anything under him or I can't transfer any assets to him because he's not over the age of 18. Maybe we can use a family trust to hold the assets until he's ready. So bottom line is you may not have all the answers, but there are still tools in place that will help you hold these assets in certain circumstances in a transitionary period. So bottom line is, even if you're not ready, you just got to get started. Some planning is better than no planning at all. Estate planning also involves working with a lot of competing priorities. You will have competing priorities because your goals will continuously change over a period of time. And what I mean by that is, let's say again, if I was married 2 times, my competing priorities is that I got to take care of my spouse today, but I also have to make sure my kids from my previous marriage are still taken care of. 2 competing priorities, but we still got to make sure we put plans in place. So bottom line is, estate planning process as a whole, it's a process that's going to continuously evolve. We just got to start, and it's an ongoing process. It's not one of these things where you start a will, or you get a will done, or you get a trust done, and then all of a sudden you say goodbye to it, you don't touch it. You're just putting things in place to start with, and then you continuously change that and evolve that as part of the process.
First of all, I'd like to thank Wealthbridge and Chen for inviting me. This is my favorite topic. So I'm going to give you guys some insight on how to do that. The most important part about this, guys, is planning. It's the planning element, right? You do it early enough, then there's no mess, and then you don't need to hire lawyers to deal with that mess. And you do it well enough, then you can keep as much of that from CRA from you and keep that back into your plan. So I'm going to talk about just exit strategies. How many of you guys own businesses where you're the sole owner? How many of you guys own businesses where you're partners? Okay, so it's a very different consideration for both of you, right? So how many of you guys started the business when you started the business, you thought about exit strategy? Good. It's good. It's very rare, but it's very important to do that. I manage a law practice. And when I started the business, I thought about exit plan. The reason is it also helps you inform how you manage and how you structure and how you do that. If you do that early on, then it's again planning ahead, then you don't have to think about that later. Obviously, business is a form of revenue for us, all right? But we have to look at it as an asset as well that we can get rid of. And that element of exiting the business is part of the business cycle. And so it's very important for you guys to think through that. So I'll kind of use my example as I went and I bought a business. So the lawyer before me, he had an exit plan, whether he had it planned ahead of time, but he had an exit plan. And I was the succession at that time. I had no relationship with I wasn't in the firm. I was an outside person that came in. I also was a lawyer. I also wanted to start a business. And I thought, do I start my own business or do I buy an existing business and run it? And I chose to buy an existing business and run it just because of all the infrastructure that he's built up. Now, if he did not find me and he did not sell, his other option would have been, because he had a timeline that he had to stop, his other option would have been he had to exit the business. And to exit the business without selling it, you're actually incurring a cost. So for example, my father ran a grocery store, and he ran it for 15, 18 years. And because he didn't think about exit planning, by the time he had to stop working, he had to just give up inventory, like sell it, and it almost was a loss for him to get rid of the business, as opposed to if he found somebody ahead, nurtured them into that business, and came up with a financial plan to do that, minimal financial plan. Not only would he have not lost money, but he could have made some money out about that. So similarly, this exit plan is very important for you to think about how you end, because it could cost you if you don't think about it. Even if you're not making a big amount of money, you have clients that you've serviced that might have problems with that after. You'll have headaches after that. So the exit plan is always good. Even if you're not making big money on it, you're handing over, like the example of a baby, to somebody else to take care of it. So when I went in, I bought the practice. I have a son. I don't want him practicing law. So I have no people in my family to take over. So I decided I need to get my succession planning from within. So our law firm has lawyers in it, and it's a common practice where lawyers come up the chain from associates to associate partners to partners, so that they eventually become my exit strategy. And so this is the thought process I did when I entered that company. So there was already an exit in that process. I'm entering and I'm looking at my exit. His exit was, and this is the two type of, his exit was selling the business. He sold the business, got a payout, and got walked out. And in a law business, you have a lot of post-exit problems. So you also want to find the right person. One of the reasons that he and I struck a deal because he trusted that I would take care of his problems post-exit, because those do come up, right? And so when I got in, I didn't think that I would exit like that. I thought, you know what, the best way for me to exit is to have my future partners buy me out and give me an exit plan. That could be a long-term payout. I don't need a big check walkout. I could have structured like a big check. I could structure it like an ongoing payout. So these are the two options that all of us have to exit. And it's a very important consideration you should do, and you should do it. If you haven't done it, you should start doing it now. Business and family succession planning, guys, the stat is that 33% of people consider their business as a way to pass on wealth or a system to their children. If you guys are in that system, then that's a great succession planning. And obviously, make sure that your children want to take it over, because that's also an element. But it's important, and if the more valuable your business is, the earlier you want to think through this to absolutely, one, save tax monies, because there are techniques you can use to ensure that you pay the minimum taxes while you're handing it off, and then focus on management, because just any partnership is hard to deal with because of decision making. So when you have another layer of complication, a dynamic of family, that adds a level of complication. Here are the estate planning tools, guys, and business planning tools for exit. You guys know most of it: marriage contracts, partnership agreements, shareholder agreements with buy-sell clauses, trusts, power of attorneys, and wills. I'm just going to quickly go over a couple of the important ones here. The estate planning ones I'm not going to touch, but I'll touch on the business side ones. So the importance of a shareholder agreement with a buy and sell clause, right? I'm just dealing with a partnership that was sort of an example of partnerships. They were really good for the time that they were my clients, and all of a sudden something happened in their life where they had to go separate ways. And when they had to go separate ways, they didn't have a shareholder agreement between them, because many don't. And because they didn't have a shareholder agreement, they didn't have exit clauses naturally agreed upon on that. So if you don't have exit clauses naturally agreed upon, and then you get to a point where you need to go separate ways, at that point trying to negotiate how you will do that is impossible. It is nearly impossible, because guaranteed at that point you guys will have divergent opinions about at that situation how to do it. So it became a landlock. It became a lock where they had to now either spend a lot of money litigating this for this. They had to both walk away from it. It was just a very tough situation to be in. A shareholder agreement with one clause could have given them the ability to go through a process that would have got one of them out. And for example, everybody knows or has heard about the shotgun clause. It's a clause in the shareholder agreement that allows you to exit one partner or out without having to go to court, and that's by doing an offer, or it's a you buy me out at this price or I buy you out at that price kind of. And so if they had one of those clauses in their shareholder agreement, it would have been a smooth transition. 90 days later, one of them would have owned the company, the other would have walked out for a fair market value. So exit strategies are good. In the shareholder agreements, you're going to be dealing with disputes. When marital breakdown happens, making sure that you considering whether you want to protect your asset from the claim of a spouse. Even upon death, you want to think about how you protect against the estate. Does the business have the rights on the shares, or does the estate have the right on the shares? You would want to think through. Again, if somebody falls disabled, what happens in that situation? When you're a sole owner or when you're a partnership owner, how do you handle dealing with that person? Because most people will resist at that moment as well. I used to work at the Office of the Public Guardian and Trustee, which was the office that dealt with mentally incapable adults, and some of them fell ill or mentally incapable while they were running a business, and it becomes a heavy, hard issue, because usually the incapable person doesn't want to let go, and then there's a push and pull between the other partners and how to work the situation, and it becomes really complicated. So that's a rare occasion, but when it happens, these are very, very important clauses that should be in the system. Estate litigation you spoke about. It's the best practice for lawyers, because you have families that don't agree and you have a pool of money that you can bill against until they agree. So if they don't agree, you're making money. If they agree, then your money stops. So it's a practice for lawyers that is a good practice. Family law, estate litigation, anything to do with people who are emotionally fighting and they don't learn to resolve it themselves, you're going to allow the system to drain you guys out of that, whether it's family law, whether it's estate litigation. So make sure that you guys have agreements in place for that. Obviously, retirement, bankruptcy, insolvency, illegal, these are all conditions that we think through in a shareholder agreement while you have partnerships amongst yourself. Trust, I'm not going to go much into trust. That's a higher level of planning, which is very important. You could do it inter vivos, meaning while you're alive, and you could do it post passing away as well. It's a good tool to tax plan. It's a good tool to prevent liability affecting your donors. It's a good tool if you have underage or incapable children to protect for them throughout their lives. It's a good tool to protect common law spouses and give them earnings over time. Generally, it's used to give a hand. A trust, everybody knows, is just a difference between you separate the legal owner with the beneficial owner, right? And so the legal owner is the one that is controlling the beneficial owner. The beneficial owner gets protected from legal stuff because the ownership is separated. It's something that I think most people don't need for the most part, unless you need it. Like you have these kind of specific situations that comes, or you get to your business gets to a level of wealth that becomes a good tax planning initiative as well. Last one, guys, is business risk. A lot of people in the industry say, like, this is where money is made. Properties are lost. You get good property deals when divorces happen. You get good business deals when property happen. There are salespeople that when there's a marriage breakdown, they get a lot of business out of it. Again, because of the situation that the people haven't figured it out themselves, they're going into a system, and the system will generally make it hard for this to happen, and a lot of people are coming in. So again, pre-planning these kind of things are the best things you can do for yourself and your future self.
For me, this is the part that I get actually excited a little bit more about in comparison to the legal side of things. But essentially, tax planning is a huge component of estate planning in general. The reality is that taxes and CRA can consume a good chunk of your capital when it's time to estate at the end of the day, right? When it comes from an estate perspective. And for me, it's not just, when we say tax planning, it's not really just about, how do I sort of minimize the tax for this year and I move forward? I put some RRSPs in so I get some credits this year, or a deduction, and I move forward. How can we now defer taxes from being paid from this generation to another generation? Is that a consideration that we have to have? Are there exemptions that we have that we can take advantage of? So a lot of business owners may or may not know this, but a lot of business owners have something called the lifetime capital gain exemption. Provided that your business qualifies for a qualified small business corporation, and there are various rules that apply to it, provided that you qualify for those, if you were to sell your shares of a corporation and you sold it for $2 million, you don't have to pay capital gains for up to $1.25 million as of today. The number was about $1 million something a little bit before. It's at now 1.25. It'll continue to go up against with inflation. Bottom line is there are exemptions that are available for you. And then the last part is, can you structure certain tools for you to be able to minimize the taxes you pay? And one thing is, and I've said this before, whether we like it or not, we're going to have to pay some parts to taxes. And we hear this quite a bit. So I think they predicted that there's going to be almost about a $90 trillion assets to be transferred from one generation, from the baby boomers to a lot of the millennials over the next 20 years. CRA is waiting. CRA is waiting for them to earn their share of that $90 trillion. Can we now, put structures in place so that people, and this was in the news quite a bit many years ago, when the millennials, when they don't have the ability, or when they don't have a funding mechanisms to pay these taxes, they'll end up being forced to sell some of those assets so that they can essentially fund that tax liability. So if somebody is building these assets as business owners, as high net worth individuals, we are building these assets so that it can truly become an intergenerational capital gains and deemed disposition. So CRA, so if anything happens to me, let's say most of my assets gets rolled over to my spouse. When a spousal rollover happens, the tax impact is very minimal. But where the biggest impact will be is when the second of both spouses actually pass away. There is something called the deemed disposition or capital gain taxes. I've built a real estate portfolio that's worth $10 million. CRA will deem that on the day the second spouse passed away, the assets were sold at the fair market value to those children. What that means is there's a huge capital gain implication and deemed disposition taxes that has to be paid on your estate. So it's important to make sure we actually plan for that. A lot of people, if you're on the corporate side, accumulating RRSP is a very common methodology. And it's also important that a lot of times business owners, before they get into the business, they might have accumulated a lot of RRSPs, or some of them actually accumulated a lot of RRSP throughout the process as well. A lot of people don't think about this, but 100% of your RRSP, let's say you had a $500,000 RRSP portfolio when you passed away, that $500,000 is 100% taxable on the year you pass away. We don't think about that often because it's there. So I've said, hey, sometimes if you're in certain ages, it might actually make sense to liquidate some of your RRSP on a yearly basis and use that to fund your lifestyle, instead of you actually, accumulating such a large RRSP, portfolio, and then you pass away and then you got to pay taxes on 100% of it. Last part of it, tax-free savings account. TFSA is one of those tools. In addition to principal residence, TFSA is another tool where it completely passes tax-free. The fundamental difference, though, is, and I think a lot of advisors or planners like us are actually talking about this now. A lot of people have beneficiaries on a TFSA, so it'll go down to whoever we want on a tax-free basis. But we can also name a successor holder for a TFSA. The reason I say that, let's say I built a $200,000 TFSA portfolio. I passed it down to my kid. I passed away. I made sure she's the beneficiary. But at her hands, that $200,000 is now a tax-free money. But if they don't have any other tax-efficient vehicles, that $200,000 loses the ability from a tax-free perspective at that point. If she has no other tools except to put that in a non-registered investment, now that becomes a taxable income at that point. What you could do is you can actually make your spouse or somebody else a successor holder of the TFSA, which means the TFSA in its original status will retain for your spouse as well. So in addition to her limits on the TFSA, she's now able to use another $200,000 portfolio that you've built up as part of the TFSA. We don't often talk about that as much, but that's a tool that's actually available, because you can actually, beneficiaries are common on TFSA, but we don't talk about the successor holder as much. To be honest, I actually didn't know that until about a couple of years ago, so we started talking about it a little bit more. So that is something that's possible as well. Whether we like it or not, when we pass away, there's probate fees. Unfortunately, Ontario is one of the higher ones. I think BC might be a little bit higher than us, but almost 1.5% of your assets that go through the probate process or go through the will, you'll end up paying probates on it. Probate is a process where your will gets probated through the court of law to be like, hey, the will is valid, now assets can go through, but they'll charge you a fee for the courts to do it. If you have a lot of wealth, they'll get 1.5% of that. And executors' fees. I know we don't talk about that quite often, but executors can also charge up to 2 to 5%, 3 to 5%, depending on the complexity of the assets. I know we talk about this quite a bit. Sometimes it's common for us to have our spouse or somebody in the family to be an executor. And if you don't want, and what some people would do is they'll have a corporate executor, like let's say an RBC trust or whatnot, and they'll have a family member as joint executor together. So you have a family member who can bring in the family value, but you also somebody who can come in very impartial, very neutral per se, and you can have a corporation that can actually be the executor, but that comes with a fee. So when you pass away, in addition to all the taxes, you're also going to have to deal with a lot of these, obviously, fees as well. So what I wanted to do is quickly do a quick case study, or just like a quick example of a very normal person. I mean, if you've been in the business and just very common for me to say this, but like a lot of especially within our own community, maybe the last 10, 15 years didn't see this as much, but this is very common. In the next 20, 30 years, it'll be much bigger than this as far as I'm concerned. A $12.5 million worth of estate. So primary residence, 1.8 mil, a business that's valued at $3.5 million, family cottage at 2.7, an investment portfolio at 3.5, and some RSPs and TFSAs. Very common type portfolios for a successful entrepreneur, or they may not have it, but bottom line is very common, something like this. Anybody can guess what, like if we were to do a very rough calculation, what percentage of that will end up in CRA's hands if you passed away today without any plan? Anybody? Just at a very high level? So I hear the word 15. 15? 50? 50? 25%? Yeah. 20? Yeah. So a good chunk of it. So truth be told, it comes down to about 15%, but I haven't taken into consideration executor and probate, which will end up being actually 20%. So when I did it, it was about 20%. But I'll quickly just walk through this, because I think I did find this to be just a bit more interesting for us to talk about. So primary residence fair market is about 1.8. The cost was $750, but there's no tax implications because primary residence is truly tax free when it passes down. Your business is valued at 3.5. Let's say there was a nominal cost of $100,000 to acquire the business or what you put in. The capital gain is only about 2.15, assuming that you actually get a lifetime capital gain exemptions on that. Your shares were qualified for it. You get 1.25 exemption. So there's obviously a gain of 2.15. And with the new rates of first 250 at 50% and the remaining at 66%, that's your capital gain. And if you were at a pretty marginal tax bracket of 50%, given you're that person, you'll end up owning about $700,000 to CRA. Family cottage, 2.7. You purchased it for 1.6. Gain is 1.1. At 66%, 691, 345K. 3.5 worth of real estate investments, etc., and that's going to be the capital gain. Your RRSP, 100% taxable, so the 450 will be 100% taxable, so that'll be about 225. And TFSA, just like I've said it before, completely tax-free, no tax implications at all. So your primary residence and your TFSA, we've determined truly two asset classes in Canada that's completely tax-free. Your primary residence, the exemption you get, and your TFSAs. I was talking to Val, and one thing to obviously note on this subject is you don't always have to claim your primary residence, the house you live in. there are ways for you to be able to do a bit of tax planning. If there's another asset that actually, has a bigger gain and you want to claim that as a capital, as a principal residence, there's a bit of flexibility within the within the tax system for you to be able to do that. Just naming it out there, I've just, for our purposes of the illustration, I've claimed the primary residence as the home you live in. But if you have a family home and then you have a cottage, but on the year you passed away, the cottage seems to have a bigger gain, and there's ways to be able to claim that as a principal residence exemption, you do have the ability to be able to do that as well. So whether we like it or not, there's about a $1.9 billion tax bill, and this does not even include the probate fees or the executor fees, which will end up being another $250K, give or take, at the end of the day, or 200, 300K, right, depending on how we see it. So there's a $2 million tax liability that's waiting for a lot of people, if you did no planning whatsoever. I wanted to talk about a few planning methodologies that are available. We're going to get into some of the simple stuff, and then I wanted to kind of get into some of the more complex stuff just as examples. Joint ownership. It's a tool that gets used, quite a bit. So let's say if I owned one of the rental property just in my name, and if it's worthwhile considering, I may add my spouse as a joint owner on that property. I may add her because then that property does not have to go through the probate process. I may be able to get away without having to go through that process. Another example, when I speak to some of my senior clients, I do tell them, hey, maybe you should, and if they just have a bank account, for example, I tell them maybe you might want to just add your kids as a joint account holder on that bank account, just so that when you're no longer around, they don't get the runaround. They can just simply access your bank accounts and all of that stuff if you want. There's also other considerations. So sometimes people will be like, hey, why don't I add my daughter as on that property? Always keep in mind you can do it. There are implications that come with it, but there might also be negative implications that come with it. For example, if that daughter is now going through a marital breakdown, now this property that you built is at risk just because. So I always say we can do tax planning, but sometimes tax planning is not everything. So sometimes it'll make sense to, make sure assets are structured a certain way. You'll end up paying probate fees, but from a protection perspective, you'll end up making sure your assets are secured. So always important consideration. Designated beneficiaries. So if you have life insurance, RRSPs, obviously make sure there's the beneficiary listed on it. That way it goes directly to the beneficiary. We talked about some of the successor holder when it comes to TFSA. Lifetime gifts that you can, while you're alive, you can give some gifts to people. Keep in mind there are tax implications that come with it. There are attribution rules that might apply in certain circumstances. Bottom line is it could be a consideration if you don't want to go through a probate process, but that is there as well. Estate freeze and family trust. So I'll quickly touch base on that just a little bit after. And I know Kubes talked about this a little bit. If you want to find out if your neighbor had a will and you want to know what he did with that will and what he did with his assets, can they find that out, Kubes, if they go somewhere online? No, they won't be able to find that out. Yeah. So I know with one of the things with family trust is also completely private as well, right? So same thing, bottom line is you want to keep things from a private perspective. You have the ability to be able to implement family trust. I'll go through a quick example from a tax perspective, just at a very high level. Again, like Kubes said, it may not warrant, the scenario may not warrant for everybody, but you want to truly keep your assets completely safe from creditors, build generational wealth, get into some advanced tax planning. I'll just give a flavor of what it's like today, but it's really not advisable for everybody at the end of the day. Tax deferrals, mechanisms that are available, usual cases. Life insurance, charitable donations, we'll touch base on that a little bit later. But these are some of the tools from a financial perspective. Kubes kind of talked about some of the tools available from a legal perspective. These are some of the tools available from a financial perspective. I just wanted to quickly talk about this. Everybody we'll look at the left side first. This side over here, very common for most people. So you're an individual, you own 100% of a corporation, and that corporation obviously has a business. Income comes into that corporation, and from there you either take a dividend or a salary. Accountants will say, hey, maybe take some as salary, some as dividend. For me, two things why some of this is actually important to consider, especially once you're in the high net worth phase. First thing, the creditor protection we talked about. Imagine this company was actually holding all of your assets. There's $500,000 sitting there right now, just by earnings of revenue. And all of a sudden, there's a lawsuit that comes your way. Now, all of that money that's sitting in that corporation, because if somebody is going to come after that company, they're going to come after this company. That money is now at risk. We want to basically make sure we protect that. There's a second aspect which is an issue, which is we talked about small business deduction limit of 12%. Most Canadian private corporation that qualify under certain circumstances, if they earn an active business income up to $500,000, they pay a much lower tax rate, which is about 12%, give or take. But it also, CRA also stipulates that if your company is earning certain amounts of passive income within that corporation, you lose the ability to be able to get that lower rate of 12%. So if this company has a lot of passive investments, whether it be real estate, whether it be marketable securities, all of that stuff, you now start to lose the ability to actually claim that that active income at 12%. A lot of accountants, tax experts will advise on a model like this. The individual now owns a holding corporation, and the holding corporation actually owns the 100% of the operating company. The beauty of this is essentially the operating company, because it's a child of this parent company, truly because the parent company owns 100%, any money from this company can actually go to the parent company through something called an intercorporate tax-free dividend. So completely tax-free to move money from, because it's a child company of that parent, to move money from the opco to the holding corporation, you don't pay any taxes at all. So you're able to move your money. It does two things. One, this company does not hold a lot of assets at that point. So if there's a creditor protection, you avoid any type of issues that come with that company. And second, by investing your assets through this company, your operating company, does not get impacted by the small business, by your passive income rules that came in 2019, which reduces your ability to claim that small business rate. So by implementing something as simple, they call it a Section 85 rollover. I'm not going to get into the complexities of that, but this is a very common. And I know when I spoke to Val a couple of days ago, one thing we said is a lot of people call the holding company as a real estate company sometimes, or they have assets that within it, but they don't necessarily have a true setup where this is actually under this. A lot of people have their operating company and they'll have their holding company, and they call this a holding company, and which they own both companies, but the holding company actually does not own the operating company. So you actually got to put legal mechanisms and tax mechanisms in place to ensure you're able to actually claim. We were talking about this because there was an individual, they were moving money from this company to this company, calling it an intercorporate tax-free dividend, but they were not related at all. They were just two separate companies, and they were ended up with a $600,000 tax bill after many, many years because the accountant did that. So make sure when you're getting into these guys, the session today is not meant to be tax or legal advice by any means. It's meant to introduce concepts that'll help you, obviously, from an estate planning or tax planning perspective, but it's important to make sure that we are obviously not taking that to heart. I'm going to quickly talk about something called an estate freeze. A concept, again, very advanced concept. Just to quickly kind of touch base on this. I own 100% of this company today. I actually take a salary and dividend. I'm the husband over here. That company is actually worth $2.5 million today. And my wife, she gets a salary just because we want to be able to pass down some income or split some income with her, etc. The challenge with this is, let's say this company is worth $2.5 million today, but I expect to live another 20 years. I do plan on bringing my kids into the business at one point, but when I pass away, that company might be worth $25, $30 million. Pretty very normal if you're in a very successful entrepreneur. If I don't do any planning mechanisms, when I pass away, I have a $30 million capital gain implication or deed disposition implication that I got to deal with. If you implement something called an estate freeze, I'm not going to get into it too much. If you implement something called an estate freeze, what you will end up doing is you're actually freezing the value of your share of that $2.5 million for something called the preferred shares with a fixed redemption value. So what I am saying is 20 years from today, this company will now maybe worth $50 million. But because I've frozen my shares at $2.5 million, when I pass away, I only got to pay taxes on that $2.5 million. I'm simplifying it quite a bit. Obviously, guys, there's lots of complexities to it. Just like this, holding company method, which is this, or family trust with an estate freeze, they all have their downfalls as well. Whether we like it or not, there are certain downfalls with these mechanisms. But these are some things we can do, because what I have effectively done through this is when I pass away, I don't have to pay taxes on $25 million, but my family can actually pay, it gets passed down when that next generation gets passed down. Another thing with something like this mechanisms is because there's beneficiaries, let's say I don't pass away, that company is worth $20 million 10 years from today. I have me, my wife, and my 3 kids as part of the beneficiary. So now we have 5 people. And I actually sell my company for about $10 million or $20 million in 10 years from today. Remember, if I was an individual shareholder, I would have been able to use the lifetime capital gain exemption of $1.25 million to offset. But now I have 5 people. So if I sold something for $10 million in 10 years, and because there's now 5 people involved, there would be a lifetime capital gain exemption of almost $6 million that can be offset. Again, at a very high level, but bottom line is these are tools that are legally available. We just got to obviously use it at the end of the day. We got to understand it, know it, understand the downfalls of it, which I'm not talking about. There's something called the 21-year deemed disposition rule with any family trust. Every 21 year, CRA will deem, even whether you've sold the assets or not, that there's a deemed disposition and you got to pay taxes on them. So depending on the circumstances, it may not make sense. But for creditor protection, all the other benefits that come with it, it might be beneficial. So you got to obviously analyze your overall estate plan and understand where you want to go, and then just be able to make sure we acknowledge that part of it. I'm a strong believer, whether it's a buy-sell agreements, whether it's a will, regardless of any agreements, you always got to have a funding mechanisms that's involved as part of it. And at the end of the day, there's some tax liability, whether we like it or not. And in order to make sure that we can pay some of those things, you can obviously use personal or business earnings. I usually say that $2 million tax liability. If it was a $12 million estate, $2 million tax liability that has to be paid, they can liquidate those assets and pay. I mean, there's not, like, obviously it's not the best case scenario, because you've just used $2 million to help pay for a tax liability. Or you can obviously borrow the funds, you can use your personal business. But something that a lot of high net worth individuals use is something called using a life insurance. Using a life insurance as a mechanism to actually help fund your tax liability. So we're going to quickly talk about how does high net worth individuals actually use life insurance as a tool to be able to help fund a lot of these things. Fund your estate tax liability. Very common, that $1.9 million, it's pennies on the dollars, whether we like it or not. If I was to pay the 1.9, I'll end up paying 1.9 out of cash, but maybe for a fraction of that cost, I can make sure that $1.9 million gets paid out to help fund your liabilities. Funding a shareholder buy-sell agreement. We talked about it, Kubes talked about all the scenarios where it requires a buy-sell, but can we actually fund that using a life insurance? Absolutely. Estate equalization, same thing. Previous example where that business owner was going to give $5 million worth of a business to the son, but he wants to give another $5 million to his daughter as well. Can he use that through life insurance? No questions asked. Key person coverage, very, very common. A lot of people may or may not know there's something called a capital dividend account, which is part of a corporation. It's a notional account. It is ultimately the secret funnel, which essentially flows money from a company to yourself as a shareholder without paying taxes. There's a few things that helps credit that. One of them is life insurance. It becomes a funnel to be able to move money from your corporation to yourself without paying taxes, and that's a capital dividend account. Financing strategies, very common, very complex type scenarios where people are able to invest $100,000 into a life insurance policy. It's called an immediate financing agreement, and they'll in turn around and be able to maybe access 80-90% of what they put into that policy on that year. So there's a life insurance need, so they're funding that $100,000 through their corporation, but we can turn around and actually borrow maybe 80-90% of what you put in on that same year. Tools that are available. Last but not least, which is what I'm going to talk about in the next 5-10 minutes, is charitable giving. I know it's close to, obviously many of us, a lot of us believe in giving back, obviously, to the community. But is there different ways to give back? Absolutely. And can life insurance be a tool to actually help give back as part of it? Absolutely. And the whole idea is, can you do that while you're sort of achieving a tax, benefit to you? Can you also make sure that you also obviously help a charity as well? 2 ways where life insurance policies are usually structured if they are obviously being used for a charitable giving purpose. The first one is the charity as the owner and the beneficiary of the policy. The tax benefits are during the lifetime, meaning let's say if I have a $10,000 policy, I'm paying $10,000 into that life insurance policy on a yearly basis. and the owner and the beneficiary of that policy is a reputable charity, for example, that $10,000 that I pay as premiums every year gets charitable tax credits on a yearly basis to offset your taxes on a yearly basis. But this is the big one for people with a large estate. So we call it a philanthropic estate plan. Charity is the only beneficiary of that policy. By doing this, you don't get the benefits of that $10,000 premiums that gets paid every year. But if the charity ends up paying, if the life insurance benefit when you pass away ends up paying a $2, $3, $4 million to a charity, you actually get a $4 million tax credit on the year you pass away for your estate. So that person who has such a large estate tax bill, they can actually use something like this. By doing something like this, you'll end up obviously funding a charity of your choice, which is, that has to be the truest intent, obviously. You can use it for tax purposes. But for me, if you don't fundamentally believe funding a charity is something you want to do, you might not want to consider it at the end of the day. But that is something that you can consider. So bottom line is, depending on when you want the tax benefits, if you want it on a yearly basis, you might want to consider the first mechanism. If you want it in a way where it's really to fund you want to give a large payout when you pass away, and you want to fund that tax benefit at that time, that's a huge tax benefit that's waiting for you. It's very common, right? We always have 3 beneficiaries when we pass away. The family is there, taxes are there, charity is there. If you don't really get into a philanthropic giving type strategy, you'll end up giving a good chunk to your family, no questions asked, and you'll end up giving some to taxes, whether we like it or not, but charity doesn't get anything. Right now, in that example, there's a $12.5 million estate that's waiting. $1.9 million will go to a charity, to taxes, and the $10 million goes to your family. In that same examples that we've been talking about, majority of the business owners that I speak to, they wouldn't want to do that. But hey, if you come across anybody who's okay with it, nothing wrong with it. Like, they're like we talked about this. There is the thought process. Hey, I'm giving $10 million to my kids. I don't really care to help them, get that 1.9. I would rather just, who cares if CRA takes it? But I would say 9 out of 10 people would say, hey, can we actually fund this in a much more cheaper dollars rather than CRA getting $1.9 million? Perfect example. So this is an example. So the way charitable tax credits usually work is for every dollar you give, again, very general sense, for every dollar you give, you get 50 cents of tax credits, give or take approximately. So in order to fund that $1.9 million of tax liability, we need an insurance policy for about $3.8 million. So if we get an insurance policy and then, if we get an insurance policy for $3.8 million, that'll give the charity $3.8 million of a payout. And by virtue of doing that, you're able to now wipe out that $1.9 million that's going towards taxes. But more importantly, you're actually doing 2 things. You're making sure your family gets that entire $12.5 million. You're also making sure that charity gets $3.8 million. So like I said, that has to be the truest intent if you want to actually go through this strategy, because there's a cost involved to make sure that we can get that $3.8 million. I'll be kind of stupid if I actually don't talk about that part of it, right? So I've had, and this is just a very illustration. It's a joint last to die policy. It's between 2 individuals. When the first person passes away, it does not get paid out. It only gets paid out when the second person passes away, because remember, at a spousal rollover, your tax liability is very minimal. It's when the second person passes away, there's a large, obviously, tax liability. And I used a 55-year-old. Majority of you here are not 55, but I used a 55-year-old example, and their life expectancy being 85-year-old. The annual premiums are about $48,000 for a policy of that nature. And I've used a male and a female 55-year-old when they pass away, and I've used life expectancy at about age 85, and I've net presented value that calculation at a 5% discounted rate. And it's about $774,000. So what we are essentially saying is, yes, there's a $1.9 million tax liability, but I can make sure that $1.9 million can potentially be mitigated with about $774,000, but that's not it. But in addition to that $1.9 million being mitigated for that, we are also making sure the charity actually gets a $3.8 million value. So unneeded life insurance policies. So I found this to be very interesting. I've actually just learned about this recently, and I validated this with Val, and he told me he had an experience 3 years ago when we did this. So we'll actually read this together. So it's a $1 million life insurance policy that had a cash surrender value of $42,000, and the owner was paying about $48,000 into that policy at this point. Let's assume it's a much older individual, smoker, so he's paying a little bit more to that policy. And he's actually sold the business. So as part of selling that business, he was actually just going to be canceling that life insurance policy, and he was going to take out that $42,000 of cash value that's there. Instead, what somebody advised him to do is to get an independent validation of the value of that policy. So you can actually get, just like business valuators, there are people who would evaluate, and they evaluated that policy at $475,000. I've actually just learned recently, and Pran, just because you're in the space a little bit more, I've also learned that even term policies will have some value to some extent. But so what's 475, and what he ended up doing is he ended up donating that policy to a charity. But by virtue of him doing that, he ended up getting a $475,000 tax deduction on that same year. The beauty with doing it through the corporation at that point was the simple fact that the corporation actually gets this tax deduction. It's not a tax credit where you're getting 50 cents on the dollar. It's a dollar per dollar deduction against any of your income from the corporation. So if you fund this the policy through a corporation, there's a little bit more, more benefits per se, in some extent, because you're actually getting a dollar for dollar credit, deduction. So again, just to go back to that, we obviously now have family, we have charity, and then we are making sure anything that was supposed to go to the taxes, we're actually making sure it goes to the charity. We talked about this a little bit. So just in summary, guys, just the last couple of slides. So bottom line is, many aspects have to go in, when you're sort of determining what your estate plan is. It's not just purely on tax minimization. Something as important as, hey, like for example, when do I want the beneficiaries to receive the assets? Maybe I want it so that I've had this perfect scenario where the client was like, he wants a family trust in place. He wanted to make sure that the daughter had to be at least 30 years old, and she wanted to make sure she was married and at least married for 7 years or so. I don't know where he came up with that, but for 7 years, and a few other conditions had to be met. At that time, she can take ownership of some of these assets, but until then, she can use these assets for benefit. So bottom line is, depending, or you want, for example, let's say you want to pass down the business to somebody else, and estate freeze is a perfect example to do that in a tax efficient manner. But do you want to still retain control of that company until you pass away? So a lot of factors have to go in. I'm a strong believer, as much as I love talking about taxes, working with Val and Chandran, as much as I love talking about that, bottom line is you got to think about life circumstances, your personal belief on certain subjects, in order to make sure that you're actually doing an estate plan that's actually worthwhile. Everything from obviously fair treatment, relinquishing or retaining control, public versus private, obviously all that goes in. A lot of people are actually involved when you actually put an estate plan together. Lawyers, accountant, tax experts, financial and estate planner, and chartered business valuators, probably at a very basic thing. I haven't worked on this particular case personally, but I've seen case notes for that. They've actually had like their physicians involved. They even had like business coaches and mentors involved as part of the process. They had psychological coaches involved, because to help like truly successful entrepreneurs, lots of things going on. So you can actually have a cascade of maybe 10 different people who are advising you on what some of the best ways to actually structure certain things. These guys can help implement that solution at the end of the day, but the ultimate goal comes down to the client. And I say these guys, or we should be able to help implement these solutions, but ultimately it'll come down to the clients to be able to know, like, what are my goals actually? We should actually help ask all the questions to understand the goals, but clients need to know obviously a lot of that aspect. We typically work in a wide spectrum of our services, depending on where the business owner is in the spectrum of their path at this point in time, whether they're in the early stages, whether they're in the succession part of things, or whether they're talking about estate planning, or it's as something as simple as, hey, I'm building a multi-million-dollar business. I want to make sure if I'm not here tomorrow, I should have a simple term insurance to make sure that the business can continue on. Or something as simple as, hey, I just came across a major illness. I can't actually work for a couple of years or a year. I always say this at the end. It's not just about building, because that's what business owners are good at doing, because that's what they're trained to do, wired to do. We want to help make sure we can help preserve it and transfer those assets in the most tax efficient manner. That being said, guys, thank you for all of you for being here.